Good day from wherever you are watching, and thank you for tuning in. My name is B.Wessels. I'm an emeritus professor of international insolvency law from Leiden University. I retired 6-7 years ago. The other speakers of this kennisclip or knowledge clip are Professor M.Haentjens from Leiden University and Dr. S.Guo from China. Both will introduce themselves. Our theme today relates to global financial and banking crisis of the last decade, and we highlight only one specific problem, which is how to protect a claim of an individual account holder that has deposited money with a certain bank when the bank goes bust. Let me introduce our work, which forms the basis of the presentation of today. First, I will address a bit of the background of our international research. Secondly, the curiosity that has driven us to entertain this work. Then the approach that we took, and lastly, the outcome of our study. Well, the three of us have been busy working some 5 or 6 years on this topic. And because you are young academics and presently thinking about writing a thesis, master thesis, let me briefly explain how we started and organized our studies. The legal and financial world since the 1990s many times has focused on American research or European research, especially in company and insolvency law. American solutions have been welcomed. For instance, the present tendency in insolvency law to look at Chapter 11 of the US Bankruptcy Code. The Royal Dutch Association of Science, or the KNAW, offered the opportunity to shift our focus to China. It had started 5-6 years ago a scientific cooperation between the Netherlands on the one hand and China on the other hand, the so-called China Exchange Program. And the Hazelhoff Center has applied for a grant of the study. Personally, I had already worked with Chinese researchers. In 2015 and 2016, 2 of them had presented their PhD and they defended their studies with regard to sovereign debts, so debts of states, and cooperation between mainland China, Hong Kong, Macau, and Taiwan in the recognition of insolvency judgments in China. And they defended, as I said, their PhD in the academische, the academy building. Well, of course, we were curious, and curious is the main engine to do research. We knew a lot about Europe and the US, but we had hardly ever touched on research together with China. And there was more reason for it. First of all, Europe was a rather large victim of collapsing and financial problems, loaded banks. And in China, that was not so much the case. On the other hand, in Europe, the last 10 years, there's a rather institutional framework still fragmented and in development, a legal framework to deal with recovery and resolution of financial institutions. And in China, that is still in very beginning. We approached our study in 3 different ways. First of all, in our project New Bank Insolvency for China and Europe, we applied a multidisciplinary approach, meaning that we looked at legal areas not only in banking law, but also private law, financial regulatory law, insolvency law, company law. That is multidisciplinary approach of our study. Secondly, it's multi-jurisdiction. Not only pan-European rules, not only national Dutch rules and national mainland China rules, but also comparisons with important legal systems as there are in England and in Germany. And thirdly, multi-level approach. Multi-level means we not only look at hard law, black letter law, treaties, acts, regulations, and so on, but also how problems are solved and approached in practice by information exchange, gentlemen's agreements between supervisory authorities, protocols, guidelines, best practices, etc. Many times, institutions in the financial field are the engines, the standard setters for these non-binding soft law approaches, such as the European Central Bank and the FSB, the Financial Stability Board. Well, finally, the outcome of our study is a book. We already had covered several issues of the new bank insolvency law for China and Europe in our volumes 1 and 2 from 2015, I think in 2016. But now in summer 2021, the third volume is there. And there we have, of course, a detailed analysis and summary of what we found. And we focus on comparing and analyzing bank insolvency, bank resolution regimes, both in Europe, of course, and in China, but also the institutional framework, the management of financial institutions, issues of contract law, issues of judicial review, for instance, of judgment of administrative decisions that have been taken. And finally, the topic that we are covering today, which is the deposit guarantee scheme. Well, the third volume, as I said, will be published in summer 2021, and Professor Haentjens, Dr. S.Guo, and I were pleased with the assistance of one of the Leiden students, Chawi Plomp, in preparing the text of our manuscript for the book, but also for inviting us to speak to you on one of these topics and on the project that has been so cherished by us for the last years. I hope you will enjoy the clip, and I hope also that we will be able to meet sometimes in the near future live.
Good day, ladies and gentlemen, and welcome to this kennis clip or knowledge clip organized by the Student Law Association Grotius of Leiden Law School. I have the pleasure to talk to you today about a research project that we have been conducting over the last years about bank insolvency law, specifically in China and the EU. My name is Professor Haentjens, and I'm a professor of private law specializing in financial law at Leiden University. Now, bank insolvency law concerns the situation that a bank falls insolvent. This may not be a day-to-day thing, but it occurs more frequently than you would maybe imagine at first sight, especially with the economic crisis that has been going on now for a couple of months as a result of the COVID-19 crisis. Banks in several jurisdictions experience severe financial distress, and they may even fall insolvent. In the financial crisis of 2008, several banks across the globe suffered from severe financial distress. In the Netherlands, for instance, there were several banks that suffered from financial distress, and as an important example of those banks, SNS Reaal went into severe difficulties, suffered from severe difficulties in the years 2010, 11 and 12. Even so, that in the beginning of 2013, it became almost inevitable that this bank had to be resolved. In that time, under Dutch law, there was no specific bank insolvency law, so that a bank that suffered from financial distress had to be resolved under normal corporate insolvency law. But this bank, SNS Reaal, being the fourth largest bank in the Netherlands, serviced 2.6 million of payment accounts. And under normal Dutch corporate insolvency law, all these payment accounts would have to be frozen until the liquidators found a solution to handle this. So 2006 million accounts would have to be frozen. People could not access the money and could not receive any monies credited to those accounts. 36.4 billion euros was credited to these accounts, which again would then be frozen. This bank, SNS Reaal, being a large financial conglomerate, also had a large insurance company. There was 7.6 million of insurance policies taken out by clients of SNS Reaal. Also, these would probably be disrupted if the conglomerate would be placed into corporate insolvency law. And that is why in the beginning of 2013, the Dutch Minister of Finance, together with the Dutch Central Bank, decided this bank would be too big to fail. If the bank would fail, this would disrupt the financial stability of the Netherlands because it performed such critical functions. And importantly, it would disrupt the access of clients to their payment accounts. And this was why the government decided to step in and rescue the bank. The government nationalized the bank so that it took over all shareholders of the bank. Now, this was not this is an example. It was not unique across the globe. In several other jurisdictions, governments stepped in to save a bank from failing. And this is why you see this cartoon here that Dutch taxpayers, in the case of SNS Reaal, but in other jurisdictions as well, taxpayers had to foot the bill, had to step in to save these banks from failing. And this was seen as an unjustified and unwanted result, because this put a severe strain on government and public finances. So that across the globe, several initiatives were undertaken to create a new bank insolvency law so that banks could be resolved in an orderly way, so that public finances would not have to be used to rescue a bank, and that a bank could be resolved in another way. So on the global level, for instance, the Financial Stability Board, the International Monetary Fund and the World Bank drafted specific rules, principles that a new bank insolvency law should probably incorporate. On the regional level, in the European Union, for instance, there was a banking union created, a union under which the supervision of banks was transferred to the European Union level, and also a new bank insolvency law was created, specific rules for the resolution of banks. Also on the national level, several jurisdictions came up with their own specific bank insolvency laws. In the United Kingdom, for instance, very early on in the crisis, already a specific act was adopted that addressed this type of bank insolvencies. That was the Banking Act of 2009. And also in the Netherlands, just before the European Union laws were adopted, the Dutch legislature introduced specific bank insolvency laws. This was the Interventiewet of 2012. On the other side of the globe, in China, also people thought about what to do when banks would fail. But the situation there was very different from in the European Union and also in the US. The global financial crisis did not hit Chinese banks as much as they did in the EU and the US. So there was less need to change the laws in China. Another factor was, and still is, that the Chinese banking system is very different from the system that we have in the EU and in the US. A lot of the Chinese banks are already owned to a large extent by the state, so that this gives a whole other dimension to the situation where banks suffer from financial difficulties. But still, also in China, over the last years, significant changes have occurred where it regards bank insolvency law. And this has been the topic of a multi-year international research project undertaken by the China University for Political Science and Law and Leiden University. This research project was funded by the Royal Academy for Dutch Science, KNAW, on our side, and on the Chinese side it has been funded by the Ministry of Education in a specific China research program that is undertaken by the KNAW and the Chinese Ministry of Education. So this has been a multi-year project specifically on this topic of bank insolvency law. And we have organized several workshops and a conference in the context of this project. On the slide you see some photos of events that we organized. We have been to Beijing, as you can see here, and the Chinese delegation have visited Leiden for the exchange of ideas. Now, let's look a bit more closely at the European changes and also at the changes in Dutch law that have been implemented since 2012-2013. As I mentioned before, in Europe, a banking union has been introduced. The first part of the banking union, as I referred to earlier, means that the supervision of banks has been transferred to the European level. The European Central Bank is now responsible for the supervision of all banks in the Eurozone, so that is all jurisdictions that use the euro as their currency. The European Central Bank does this on the basis of a directive. That is, the European Central Bank enforces the implemented provisions of the directive, mainly of the Credit Requirements Directive number 4. So this bank supervision aims to prevent banks from falling insolvent. It aims to have banks be healthy financially, have a sound structure within their bank so that they do not fall insolvent. But once they do, you need to have a credible resolution mechanism in place, and that is what the second leg of the banking union aims to do. So here we do not have the central bank, who is the European Central Bank, who is in charge on the European level, but there is the Single Resolution Board, which is in charge of the resolution of European banks, the most significant European banks. The Single Resolution Board sits in Brussels, and it enforces the Single Resolution Mechanism regulation, and on the national level, the Bank Recovery and Resolution Directive has been implemented. That directive contains the substantive norms which govern a bank insolvency now. The third part of the banking union concerns what happens if a bank does fail and if clients of the bank need to be guaranteed, needs to be refunded to a certain amount of the funds that they have credited in their payment accounts. Now, this has always been a national affair. National member states have their own deposit guarantee scheme, but the idea of the banking union was that there should be a European guarantee scheme, a common European fund that could guarantee deposits up to a certain amount. This third leg of the banking union has still not been implemented. There is considerable political opposition to this idea. Next to these three legs of the banking union, there is also a European stability mechanism, which refers to a huge fund that there is that can be used when banks suffer from difficulties and need additional funding on the European level. Now let's take a somewhat more closer look at this deposit guarantee scheme. Now, a deposit guarantee, as the name suggests, guarantees that depositors, so anyone basically who has a payment account with a bank, that this payment account and the monies that are credited to that payment account are guaranteed by the state to a certain amount. This has at least two main purposes. So the first one is that is to prevent that depositors cannot access their money. So this is a critical function. It is of critical importance that depositors, that clients, consumers, as well as companies, can always access their monies, which are to the largest extent credited to payment accounts nowadays. So this is an important element in an important aim of deposit guarantee schemes, that depositors can, within a certain time frame, use their payment accounts, because this is such an important, critical, important function of our present economies. The second one is more of a macroeconomic aim, if you like, because this deposit guarantee scheme also aims to prevent that depositors run to the bank and take out their monies once they fear that their bank will be liquidated under insolvency law. An important danger of how banks now work is that if depositors fear that their bank will be resolved, that they cannot access their payment accounts, and that maybe they will not be returned the full amount of their deposits, that they will run to the bank and take out their monies as soon as possible. This is what you call a bank run. And if all depositors take out their money at the same time, you have a bank run, and this may precipitate a bank's difficulties. This may cause a bank from even going faster down the drain and put it into a severe liquidity stress position. So once there is a guarantee in place under which the government guarantees that depositors will in any event get their money back to a certain amount, this aims to take away the incentive for depositors to run to the bank and take away all their money once they fear the bank falls insolvent. So since 2014, a deposit guarantee scheme has been, at least the rules for deposit guarantee schemes have been harmonized across the EU through the Deposit Guarantee Scheme Directive. So again, each member state had to implement this directive, which, as I just explained, has two major policy goals, namely the protection of deposit holders and also the safeguard of financial stability, to prevent that depositors run to the bank and put banks under even more stress, or even cause a bank to fall insolvent, which may have a domino effect, so that other banks will also fall insolvent and depositors of other banks also will run to their bank. Now, this deposit guarantee scheme has to be implemented, as I said, into national laws. In Dutch law, for instance, it has been mainly been implemented in the Act on Financial Supervision, or the Wet op het Financieel Toezicht, and that is Article 258 of Part 3 of this Act on Financial Supervision, and a specific government decree that is based on those provisions. Under these provisions, each depositor is guaranteed to an amount of up to 100,000 euros per deposit holder per bank. So if you would have more than 100,000 euros, it is advisable to have a payment account with one bank, under which up to 100,000 is guaranteed, and the rest with another bank. Now, under this deposit guarantee scheme, the payout term is maximum of 7 working days. So the government, in our case, the Dutch government, is under an obligation to organize that once this deposit guarantee scheme has been put into operation, once it is triggered because a bank fails, that depositors are being paid out within 7 working days. Now, it applies the deposit guarantee scheme in the member state where the bank is licensed, and this includes branches throughout the European Economic Area. So if a Dutch bank would fail and the Dutch deposit guarantee scheme would be put into operation, then also clients of the branches of this Dutch bank in other member states would be protected under the Dutch deposit guarantee scheme. So this is, if you like, the public law aspect of the deposit guarantee scheme as it has been implemented into national law. But there is also a private law aspect of it, and that has to do with subrogation. So, as I explained before, in the Netherlands, it is the Dutch Central Bank that operates the deposit guarantee scheme, and if the Dutch Central Bank pays out a certain depositor, then the Dutch Central Bank takes over the claim that the depositor had against the insolvent bank. So, for instance, if a depositor would have 5,000 euros on its payment account, and if the bank then would fail, and the Dutch Central Bank would pay out this depositor its 5,000 euros, then the Dutch Central Bank would take over, would be assigned, would be subrogated in the claim against the bank for 5,000 euros. And this also includes this includes not only principal, so the 5,000, but also probably the interest that accrues in the context of this deposit. So this has been a short introduction to the EU, what happened as of the global financial crisis in 2013, new developments that have been taken place since then, with a specific view on deposit guarantee scheme. Now this again has been developed very differently in China, and in order to give you an idea about the deposit guarantee developments in China, I happily hand over the floor to my Chinese colleague, S.Guo.
Good day, ladies and gentlemen. My name is S.Guo. I'm assistant professor at China University of Political Science and Law in Beijing. I'm also alumnus of Leiden University, where I defended my PhD dissertation last year in 2020 with the topic on recognition of foreign bank restitution actions. In the past few years, I had the privilege to work with Professor M.Haentjens and Professor B.Wessels on the project New Bank Insolvency Law for China and Europe, which is a timely and important topic for both China and Europe and even beyond. Following the introduction of Professor M.Haentjens, I will briefly introduce the system in China, with a special focus on Chinese deposit insurance systems. Unlike the EU, the Chinese deposit insurance systems only have very short history, with the Chinese deposit insurance regulation came into existence in 2015. The policy goals of the deposit insurance regulation are to protect depositor interest, manage financial risks, and safeguard financial stability. Similar to the system in the EU, in China, insurance institutions pay premiums to the deposit insurance fund managed institution and form deposit insurance funds. When there is a bank crisis, the deposit insurance fund managed institution reimburses the insured deposits of depositors and takes necessary measures to maintain the safety of both deposits and deposit insurance funds. The deposit insurance fund managed institution is now part of China's central bank, the People's Bank of China Financial Stability Bureau. The coverage of China's deposit insurance is 500,000 Chinese yuan per deposit holder per bank, approximately 62,500 euros per deposit holder per bank, and the payout period is 7 working days. This is the same in the EU. There is another important case that worth mentioning, that is the resolution of the Baoshan Bank in 2019. This is the first bank insolvency case in China in the past 2 decades, also the first case after promulgation of deposit insurance regulation. When the bank went into trouble in 2019, the Chinese Central Bank, the People's Bank of China, and the Chinese Banking Authority, the China Banking and Insurance Regulatory Commission, jointly decided to assume control over the Baoshan Bank. This is the Chinese version of restitution. During the process, part of the bank's assets and liabilities was transferred to 2 other banks, Mongshan Bank and Huishan Bank. Also in the process, deposit insurance funds were used to guarantee or reimburse covered deposits, that is, deposits below 500,000 Chinese yuan. Additional deposits for all natural persons and part of the institutional deposits below 50 million Chinese yuan were reimbursed by the central bank. The Baoshan Bank is now under normal insolvency proceedings, that is, winding up proceeding in China. To be honest, China is quite slow in adopting a very comprehensive restitution laws, as those in the EU BRRD or SRMR. The basic law is still Chinese enterprise bankruptcy law, with some special provisions in Chinese commercial banks law. However, progress has been made. For example, in 2018, the Chinese financial authorities jointly published the guiding opinions on improving supervision on systematic and important financial institutions. That is, the SIFI Guiding Opinion 2018. In this policy document, it is acknowledged that bail-in should apply, making banks that are failing and like to fail absorb losses first through self-funds and then industry funds raised from market. Also, earlier this year, the measures for banking and insurance institutions on implementing recovery and restoration plans were enacted. Accordingly, banks with consolidated assets over 300 billion Chinese yuan, that is approximately 39 billion euros, should prepare recovery and restoration plans. As you can see, the authorities are making steady progress. Bank insolvency is a fast-developing area, and we look forward to seeing how the laws are going to evolve in the future. Now, I will hand over the floor back to Professor Wessels.
Hi, and welcome back. I would like to talk with you about international academic cooperation, because what you just saw from Professor Haentjens and Dr. S.Guo is related to international academic cooperation. First, the word international. It is far away from national. For instance, as a student, national civil law or national corporate law. Of course, that's an element of international research, especially if you start to compare certain Dutch elements with German elements or with elements from the US or even from China. But international academic research requires that you are able to develop a position that is taking distance from typically Dutch law, that you present yourself and think as being open for developments that are coming from abroad. Secondly, it's academic cooperation. When I was a young student, the only thing I knew from the university is the lecturer or the professor lecturing, sometimes for 2, sometimes for 3 hours, and then you had your classes and then you went home or to your room or whatever. Only later, when you are in your 3rd and 4th year, you understand that there are other typically activities at the university. From us now at the university side, there are 3 main streams of work. First of all, education, including exams and marking, etc. Secondly, research. Sometimes there are people doing research for 80% of their time, and you as a young student, you don't see them because they don't teach, especially they don't teach in bachelor, sometimes they teach in the master courses. And of course, administration. There's a lot of organizational work and managerial work if you want to deliver the markings of your exams in time, etc. So it is international academic cooperation or collaboration. And collaboration you do to join shoulders and to in an effort to achieve a specific goal. Well, there are 3 important reasons to go into cooperation, academic cooperation. First of all, if you want to reach desired results that you know that you cannot do on your own. If I want to compare the law with regard to specific contracts in the Netherlands, Italy, and Estonia, I cannot do that by myself because of language limitations. Secondly, effective allocation of competences and know-how if you work together. You must have someone that organizes the work and is good in it, someone who wants to think about certain issue, someone that drafts. So you efficiently organize according to the competences of the people that are engaged in the team. And thirdly, that also allows to work efficiently, take over work from each other where it is possible. It decreases workload if you are not so good in, for instance, management, but you're good in the research issue and someone other takes over management, etc. So it lowers also stress. But what it also does, if you work together, is you just have fun. Well, some of the examples of academic research, apart from the third volume of the book that we have been discussing today in this clip. I'll give you two examples. The first one is this study, International Contributions to the Reform of Chapter 11 US Bankruptcy Code. This is a joint effort from me and Professor deze from the University of Amsterdam, based on the idea that the American Bankruptcy Institute in 2015 wanted to suppose changes and recommendations for changes of Chapter 11. When I heard about the project, I said to some of the people I knew there, an academic and a practitioner, mind you, Chapter 11 of the Bankruptcy Code is an example in many of the European countries, but also in Australia and also, for instance, in Japan. Why don't you listen to what those jurisdictions can say, what can improve in the American system based on the application of Chapter 11 ideas in their countries? And there were 7 themes on which we could present our recommendations, proposals to take into account. And indeed, that has been done. Another item is this one. Let me see, cross-border protocols in insolvency of multinational enterprise groups. And this is, as I said earlier, a non-binding protocol, sort of agreements and understandings to solve insolvencies between large groups of companies. A major example is, of course, the Lehman Bank bankruptcy, with 17 countries involved, fully over the globe, that have to be coordinated, and the coordination was done by the insolvency practitioners that had been appointed in all those proceedings all over the world, and trying to reach that by a joint understanding in a protocol. And Ilya Kokorin, one of the PhD students presently in his last year of defending his PhD with Professor M.Haentjens as a supervisor, we wrote together this book, which recently came out. I think it was in May or June 2021. And finally, with Dr. S.Guo, presently I'm studying for one of the European think tanks the issue of confidentiality, secrecy in insolvency proceedings and how you deal with it, because many creditors or judges or other parties, they want information in international insolvency cases, but sometimes information is privileged, or sometimes you have to treat it confidential, etc. And that's part of our study. It keeps me busy. And the final question then is, why are you doing this? Well, first of all, because I like it. I'd like to work with the younger people, and we are stepping into new areas of law that have not been discovered yet. a broad international contact, especially later if you are a solicitor or wherever you start to work as a legal counsel in a company. Your clients, many of them, will go all over the world. And a better understanding of certain legal systems in other countries gives you a better look and feel of what your clients are confronted with when they want to enter a market that for them is commercially viable, but legally so unknown. And there's quite some room for personal development. I've been to countries like Indonesia, Estonia 15 years ago, where if you are in such a country, your blinkers, your typically national look at matters, or your ideas that have been formed by reading papers of Dutch papers or research of Estonia or Indonesia, if you are in those countries, it gives you a much broader view on what is important for the people and the lawyers and the judges over there. So it widens your view on your own matters here in the Netherlands. Well, thank you very much again for your attention, and we hope that we can soon meet.